Well, welcome everybody to Municipal Land Use Planning or Land Use Planning 101 in Alberta. There's two of us presenting today. I'm Shelley Durr. I'm a municipal planning advisor with Municipal Affairs. I've been here for 12 years. Prior to this, I was a development officer with the County of Wetaskiwin. And previous to that, I was with the town of Barrhead for a while as their intern. And then I'll introduce my co-presenter.
Hi everyone, I'm Trevor McPherson, Municipal Planning Advisor here in Municipal Affairs. Um, I haven't been in Municipal Affairs that long, but before that I was at the City of Edmonton, and prior to that I worked in private sector consulting in Ontario and Alberta.
If anyone has any questions during the presentation, please ask using the chat function. Please keep in mind that the answers may be in a later part of the presentation as well. So if we don't get to it right away, we may wait to the very end to answer those questions. Please note one change on the notes that were previously provided. Slide number 5 was deleted and it's coming next. So we're going to launch poll number 1. We just want to get an idea as who's attending the session today. So what type of organization do you work for? Awesome. So I think the results are in. 31% are with a municipal district, 22% is with a village, 33% is with a town, and 6% is with a city. And then the remainder are other. So welcome to our presentation. So I'll end the poll at this moment. So we'd like to acknowledge that Alberta includes the traditional territory of the signatories to Treaty 6, 7, and 8. We also acknowledge the Métis people of Alberta who have a deep connection with this land. This information is provided for informational and guidance purposes. So this is the next slide. Sorry about that. It is not direction to municipalities and is not intended for use as a template, and it does not constitute legal advice. Both me and Trevor are not lawyers. We are planners with the province. So if you ever require legal advice, you may want to refer that to your legal advisor. So next slide. Please be aware that the session will be recorded and may be posted online. Next slide. So we've provided the slides and a note page prior to this presentation. And so you would have a copy of the agenda. So land use planning is a system of rules and processes we use to make decisions about how we use land and where we build things like our homes, businesses, schools, parks, and rec centers. Of course, there are a variety of municipalities of types and sizes present today. This presentation is a general overview of the MGA. Next slide. In the MGA, under Section 617, the Act provides a purpose for Part 17, the Land Use Planning and Development section. It says the purpose of this part and the regulations and bylaws under this part is to provide means whereby plans and related matters may be prepared and adopted. A, to achieve the orderly, economical, and beneficial development, use of land, and patterns of human settlement, and B, to maintain and improve the quality of the physical environment within which patterns of human settlement are situated in Alberta, without infringing on the rights of individuals for any public interest, except to the extent that is necessary for the overall greater public interest. In addition to that statement, it is also to guide current and future municipal and regional growth, to balance out the rights of the public and private property rights, and to ensure the cost-effective delivery of municipal services. To further simplify land use planning further, I think that there's a place for everything and everything should be in its place. whatever council approves by bylaw or through policy. So next slide. So within the slide, on the right side, you see a far side comic. You'll notice the development Crutchfield Crocodile Farm is adjacent to Anderson's Skydiving School. So if we click again, we'll see the second cartoon as Dingle Farm versus Doreen's Nursery. And so this is a question that's going to come up as the next chat question. So which developments present more compatibility issues? So you get a choice of either the left side or the right side. Which one creates a bigger issue? And if making the decision and you want to defend your decision, please put that in the chat box so that we can see what your rationale for that is. Awesome. So right now on the left side, we have more than 80% feeling that the left side is a bigger issue than on the right side. So with the Dingle Farm and a nursery right beside each other, potentially, if those dingoes get loose, the babies are in trouble, is my guess. And that seems actually rather rational. On the right side, less of an issue because a skydiving school, once they're loaded onto a plane and they're released into the sky, there's a good possibility that they will not land in the crocodile farm. So I could see that being less of an issue. So that is an excellent rationale for why the left side's a problem, but the right side, less of a problem. Thank you, everyone. So we'll move on to the next slide. So starting with municipal land use decision makers, we have council, various authorities, the appeal board and tribunals, and the Court of Appeal. Next slide. So councils approve land use statutory plans through bylaw, the land use bylaw, and other bylaws that affect land use planning and development matters. Council as a whole does not process or make decisions on development permits except for direct control. Only council has bylaw making powers and make the decisions on amendments to bylaws. However, under the MGA, section 641, that covers direct control. And more details on DC will be coming up in an upcoming slide. In part 17, this also refers to other bylaws related to planning, and there's more about that coming in upcoming slides as well. There are also non-statutory plans and policies, and these are passed as resolutions by council. And of course, there's more coming up in an upcoming slide. So we're going to advance to the next slide. So by bylaw, the municipality is required to create a development authority, a subdivision authority, or MPC. An intermunicipal service agency is created under an agreement, not by bylaw. A development officer makes decisions based on the land use bylaw. A subdivision authority addresses subdivision matters. In addition to the others related to planning, a designated officer is addressed under section 210, and a designated officer can make inspections or complete inspections. So an MPC or intermunicipal planning commission are council committees and can make development, subdivision, or both types of decisions, provided the bylaw allows for the decision making or perhaps making recommendations to the decision maker. It would depend on the municipality and their bylaw. So in this case, individual council members can be members of an MPC or an intermunicipal MPC. However, please keep in mind that there's a restriction for council members. If they're sitting on an MPC, they cannot also be on an SAB in the same matter in an appeal, as they cannot make a decision twice. Please note that under Section 197, this addresses public presence at meetings, and you may want to review the section in case it applies to your circumstances. An intermunicipal service agency were previously established under individual regulations, but today they may exist as a result of Section 602 or the Societies Act, or perhaps by municipal agreements. So it may differ from municipality to municipality. Regional services agencies could offer a variety of planning and development functions, including acting as land use planning authority for a municipality. So next slide. Council creates their bylaw for the SCAB under Section 627, or if it's an intermunicipal SCAB, that section allows for that agreement between municipalities or both. The Land and Property Rights Tribunal is covered under the MGA under Section 488. So all subdivision and development appeal boards and Land and Property Rights Tribunal are established under the MGA, but operate independently from government. So that's separate from the province and the municipal government. Council and administration have no influence over SDAB or LPRD decisions. However, the next slide will address appeal of all board decisions. So basically, under the LPRT, sections 685 on the left and 678 for subdivision on the right side. For both development and subdivision, the LPRT appeals say relatively the same thing, and you'll see the writing both in green on both sides, left and right. In addition, the slide refers to matters where there's provincial interests, such as highways, environment issues, I should say, historical sites, and tourism. Also keep note that things under Section 619 are also matters for the LPRT. If an appeal is submitted to the wrong board, the receiving board can determine whether they have jurisdiction and then may remit it to the other board to make a decision. So next slide. Decisions of the SDAB and LPRT can be appealed to the Court of Appeal only on a question of law or jurisdiction. So on our resource page, on the very final page, there will be information in regards to SCAB training. So that will be coming up later. And for the next part, I'm gonna defer to Trevor, who will be presenting next.
Okay, so for the next part of the presentation, I'm going to go over the planning and development process. First, I'm going to talk about the different types of statutory plans and what they do. Then I will talk about the land use bylaw, how stat plans and the land use bylaw work together. And then throughout the presentation, Shelley and I will both talk about different types of development applications that are part of the development process. So rezonings, subdivisions, and development permits. Okay, so this slide shows the hierarchy of policy and legislation as it relates to planning in Alberta. At the top, you have the Municipal Government Act and the Alberta Land Stewardship Act, which are the two main pieces of legislation relevant to planning on private land. Nearly all of what we're going to talk about today is focused on the MGA, as it's the legislation that outlines the rules, regulations, and processes that municipalities must follow when doing their own planning, because municipalities are responsible for planning in Alberta. The ALSA gives authority to the regional plans, which are planning policies created by the province, which Shelley's going to talk more about towards the end. So legislation is often accompanied by regulations. There are 36 sets of regulations in the MGA. The regulations most relevant to, second here. Yeah, there's 36 sets of regulations in the MGA. The regulations most relevant to planning are called the Matters Related to Subdivision and Development Regulation, which provide additional regulations mostly related to subdivision applications, approval conditions, and appeals. So under the regulations, you'll see the growth management boards. I'm not going to talk too much about growth management boards today because currently there aren't any. The province announced almost exactly a year ago that the boards would be voluntary and must be self-funded. And as a result, the Edmonton Metropolitan Region Board and the Calgary Metropolitan Region Board disbanded. However, the MGA does still allow for growth management boards, and there were regional boards prior to the most recent iteration of them, so it's possible you see them again in the future. Below that, you'll see the statutory plan hierarchy, so from IDPs down to ASPs and ARPs. And then at the bottom, you'll see the land use bylaw, which is probably the most important planning policy tool in planning. And later I'll get more into the LUB and how it works separately from statutory plans. The MGA requires municipalities to have specific statutory plans. It outlines the hierarchy of plans, which you can see on the right here, what each plan does and when they're required. Statutory plans provide high-level direction on how land will be used and what will be built where, housing, commercial, industry, parks, schools, infrastructure. As you move down the hierarchy of plans, generally they provide increasing amounts of policy detail to smaller areas of land. The MGA requires municipalities to collect and incorporate public input when preparing statutory plans. Municipalities must provide an opportunity for input to anyone affected by a plan, and specifically identify school boards and for MDPs, adjacent municipalities and reservations. So intermunicipal development plans, or IDPs, are plans that involve two or more municipalities that share common borders. The municipalities involved get to decide together what lands need to be included in the plan. So for the example you see on the right here, the IDP plan area is the area in dark blue, and as you can see, it overlaps with both the city and the county of Grand Prairie, and those two municipalities determine those exact boundaries. IDPs must address issues related to future land use, future development proposals, transportation infrastructure, environmental issues, coordination of intermunicipal programs, if any, and establish a process for administering the plan and conflict resolution. Unlike most statutory plans, IDPs are not always required, and municipalities can decide they don't need one. Municipal development plans, or MDPs, provide high-level planning direction for all land within a municipality. These plans typically provide the long-term vision for how the municipality plans to grow and develop in the future. They're generally trying to answer the question, what will the municipality look like in 10, 20, even 50 years? The MGA requires that the municipal development plan address future land use and development, transportation infrastructure, and municipal services and facilities. So on the right here, you will see part of the draft city structure map from the draft City of Calgary NDP. I hope it's not hard for you to see, but the map includes major land use categories, roads, public transportation routes, parks, walking trails. So really bringing together all the different pieces of planning into one citywide plan. Municipalities can, if they wish, address other things in their NDP related to, to quote the MGA, physical, social, or economic development of the municipality. But again, it's not required. If there's no IDP, the MDP must address coordination with neighboring municipalities on land use. area structure plans, or ASPs. The purpose of these plans is to establish a planning framework for the subdivision and development of a new area. These plans provide more detailed planning for specific areas that have yet to be developed. ASPs will establish land use categories. So on the right here, the light yellow color is residential, orange is country residential. The different pinks and reds are commercial and mixed use. These land use categories are associated with population densities and distributions, which are then used to help plan the other things on the map you see here, like the road network and parks and school sites. ASPs also plan for water and wastewater infrastructure, and they will identify a preferred development sequence. So either north to south or east to west or whatever the municipality prefers. An important thing to say about ASPs compared to other plans is that while IDPs and MDPs are amended pretty rarely, and those amendments are typically initiated by the municipality, ASPs are amended much more frequently, and those are typically initiated by developers. Area redevelopment plans, or ARPs, provide very detailed planning for smaller, already developed areas to guide redevelopment. ARPs are required to state the objectives of the plans, how they will be achieved, proposed land uses, proposed population densities, locations of major utilities and transportation routes, and if applicable, proposals for the acquisition of land for schools, parks, and municipal facilities. Municipalities can, if they wish, charge a redevelopment levy through an ARP. Redevelopment levies are fee municipalities can charge on development in the designated redevelopment area. Redevelopment levies must be used to fund land for parks, schools, or rec centers, and they are collected at the time of development permit. So the land use bylaw. Land use bylaws, they're very different from statutory plans, but they work together with them. The land use bylaw implements statutory plans through zoning and the detailed development regulations associated with each zone. Something I want to say here is that while providing detailed regulation might not sound as interesting as the sort of big vision of the MDP in terms of planning, the land use bylaw really is the most important planning tool a municipality has. It's not just a vision like an MDP or a framework like an ASP, it's the regulatory tool used to manage development day to day. Important part of what land use bylaws do is they identify permitted and discretionary uses in each zone. Permitted uses are uses that are always allowed in a zone. And discretionary uses are those that a development authority will consider. An important element to that is that if a development permit application complies with the zoning regulations and it's a permitted use, the municipality is legally required to approve the permit. And then on the other hand, discretionary use permits or any permit decision where the development authority exercises discretion can be appealed. Another very important part of what land use bylaws do is any land use bylaw must outline the municipality's process for issuing development permits. Just to explain a little more about how the land use bylaw implements statutory plans. So I talked a bit about ASPs. ASPs are essentially sketching out what a new neighborhood or a new area of a municipality will look like and is laying the groundwork for that vision. They identify housing types, population densities, use that information to identify road networks, retail, parks, schools. And then the corresponding zones from the land use bylaw are applied based on the land use designations from the MDP. So if you look at this diagram here, shows roughly what a land use map and an ASP would look like. You see the land use categories, and then you see how they change to the corresponding zones that would be applied in the land use bylaw. So the ASP provides the planning foundation, and then the zoning bylaw applies detailed regulations based on that foundation. Yeah, sometimes planning is a little hard to understand. I find sometimes people look at a land use map and a statutory plan and then look at a zoning map, and it's hard to tell the difference. But if you dig deeper, you'll see they do different but complementary things. Um, yeah, and then just to further illustrate that point, this is just an example from the City of Edmonton's new zoning bylaw. Um, just a couple diagrams showing side setbacks on row housing, and it gives you a sense of the level of detail the land use bylaw operates at and what it does that statutory plans do not do. Um, I mean, the diagram on the right shows varying side setback distances based on the type of steps leading up to the side entrance. So it's very granular, and you won't find that in the stat plan. Land use bylaws can be amended. Um, Sometimes municipalities choose to initiate their own amendments. They might make significant changes as part of a periodic review, or they might change specific regulations that aren't working on it as intended. That latter type of amendment is sometimes referred to as a text amendment when they change the regulations, the text of the bylaw, but not the map. So the zones, so which zone applies where doesn't change, but how the zone works will change. Um, Much more often, though, land use bylaw amendments are initiated by land owners and are site specific. They submit an application to the municipality to change the zone that applies to their properties, and these types of amendments are more often called rezonings. Um, yeah, so just an example on the slide here. You have the initial municipal zoning FS1 or SF1, and then a developer may apply to have it changed to large lot single family residential. Um, Landowner initiated rezonings of this kind are very common. Um, I know a lot of people here at municipal districts, so smaller municipalities will encounter fewer, but councils at large municipalities will pass a number of these types of rezonings every week. And every rezoning will need to go through the standard planning bylaw adoption process, which I'll touch on in a couple of slides. So one more type of zoning tool I want to talk about is called direct control districts. These allow council to directly control the creation of land use bylaw regulations that apply in a specific area. So a council can designate an area a direct control district within the land use bylaw. And then once they've done so, they can regulate development in that area in any way they consider necessary, as long as it's consistent with the statutory plan. So how that typically works is the council will provide direction to administration on how they want to regulate an area. They'll have a purpose or a goal they're trying to achieve. Administration will draft regulations to achieve that, which will then be brought back to council for a vote. Yeah, as you can see on the slide here, they can regulate in any way they consider necessary. So these types of regulations are often very detailed and specific to an area or a parcel. DCs can be applied to larger areas, and councils can use DCs as a tool to achieve larger planning goals in an area, or they can be site specific that might be used for large, complex private sector developments. Um, in a direct control district, council can decide on development permit applications themselves, or they can delegate that decision to a development authority with specific direction. If the development authority decides on the application, it can be appealed to the SDAB, but only on the grounds that council's direction was not followed. Yeah, as mentioned earlier, there's a specific process for passing planning bylaws. Section 692 of the MGA outlines these requirements. It applies to all statutory plans and land use bylaws, including any amendments to those plans or bylaws. 3 readings are required before council, and a public hearing is required prior to second reading. If a proposed development requires both a statutory plan and a land use bylaw amendment, only one public hearing is required for both those amendments. Section 692 also requires notice to be provided when passing planning bylaw and outlines who needs to be notified, depending on what type of bylaw. Um, yeah, statutory plans and zoning bylaw amendments are sometimes part of the development process, and council always needs to vote on them, but subdivision and development permit decisions are delegated to other authorities. We'll start talking about some of those now. So subdivision is the process through which new parcels of land are created. Both municipalities and landowners participate in this process. Subdivision is regulated by municipalities through their land use bylaw, and it is regulated by the province through the MGA and the subdivision and development regulations. I'm going to talk more about the process next, but an important element I wanted to mention that is that reserve land for roads, schools, utilities, that sort of thing is collected through the subdivision process. So on this slide is just a diagram of the subdivision process. The process is initiated by the landowner by submitting an application. The subdivision authority has 20 days to review the application and either ask for more information or deem it complete. Once the application has been deemed complete, the subdivision authority has 60 days to review and make a decision. They review to ensure compliance with municipal statutory plans, land use bylaw regulations, provincial subdivision and development regulations. And depending on the nature of the application, it may be referred to provincial agencies. Once the subdivision authority has made a decision on an application, they must provide the decision and the rationale in writing to the applicant. Subdivision approvals often come with conditions, and subdivision approvals often come with conditions that the applicant must meet before the subdivision can be registered on title with the land titles office. Applicants can appeal just the conditions of approval to the SDAB, and these are typically the most common type of subdivision appeal. After 60 days, if the subdivision authority hasn't made a decision, the applicant is deemed refused. The application is deemed refused, and the application may be appealed to the SDAB. Appellants have 14 days to appeal any decision. Yeah, so I mentioned land dedication is part of the subdivision process, so I'm just going to turn it over to Shelley now to talk a little bit more about that and the development permit process.
Awesome. Thanks, Trevor. So Trevor will have to stand by. Oh, wait a second. Oh, that actually is going to apply to the next slide, so I'm already ahead of myself. So for land dedication, this is under section 661. Land dedication is a process by which lands are provided to municipality or the province for community uses as required by the subdivision authority at the time of subdivision. 661 addresses dedication of these items without compensation, and these are the ones that you'll see on the side highlighted in green. So road and utilities are up to 30% are taken to ensure subdivisions are serviced. MR, SR, and MSR is up to 10% to ensure there are lands for parks and/or schools. Please note that the chart does not mean 10%, 10%, and another 10% when it comes to reserve land for MR, SR, or MSR. It is a total of 10% of land or money in lieu, or it could be a combination thereof.
I don't have any headphones here.
In regards to reserve lands set aside for schools, section 672.3 addresses community services reserve for land designated for school site, but is no longer needed for a school. A surplus site, this now becomes a surplus site. This allows for additional community uses such as a public library, a police station, a fire station, or ambulance service facility, or a combination of them. It could be also a non-profit daycare facility, a seniors facility, special needs facility, a municipal facility providing service directly to the public, And finally, affordable housing. The disposal of school reserve is limited to the additional community uses. So should a land that was set aside at one time with a plan for a school and the parking lot is now deemed surplus, and it goes through Alberta education's process under their legislation, and their minister signs off saying it is surplus. It goes back to the municipality, and those additional uses can now be considered under those lands designated as MSR. So in addition, back to this chart, under 664 for environmental reserve, ER is used to protect specific areas with environmental features. For example, shoreline or ravines. If it meets requirements for reserve land, then that land is protected from development. There have been cases in Alberta where land was developed on environmental reserve, and it was not at all positive. It was very complicated, it involved courts, and it was very expensive. And finally, under section 664, conservation reserve. This is brand new. That was introduced when there was an MGA review back in 2020. So this was introduced and now an option for municipalities to use to preserve natural landscapes, but it doesn't meet the ER requirements. So unlike ER, which is dedicated without compensation, conservation reserve is a compensatory dedication, not dedication. It's compensatory. So basically the municipality would need to pay to get that land. And then we're going to move on to the next slide for offsite levies. So Trevor will have a lot of clicking to do because that's how I set up the slide. So offsite levies are used to fund the cost of new or expanded community facilities and infrastructure necessary to service a development. A bylaw may not impose an offsite levy on land required for a school building project that is owned by a school board or leased to a school board in accordance with section 187.1, subsection 4B of the Education Act. So an offsite levy may be used only to pay for all or part of the capital costs of any or all of the following: new or expanded. So click once. So for the storage, transmission, treatment, or supply of water, click again. Facilities for treatment, movement, or disposal of sanitary sewage, click again. Storm sewer drainage facilities. Under C.1, click again. For new or expanded roads required for or impacted by a subdivision or development. C.2, subject to the regulations. New or expanded transportation infrastructure required to connect or improve the connection of municipal roads to provincial highways resulting from a subdivision or development. As well, any of these above the blue line you may acquire land for or in connection with any facilities previously described. So in addition to the capital cost of facilities previously described, an offsite levy may be used to pay for all or part of the capital costs of the following purposes. So they could be for recreation, community recreation facilities. So whatever that means for your municipality, which is why there's a question mark in the middle. It can also be used for fire hall facilities, police station facilities, and finally, libraries. And for the facilities, that is, and not operational. So municipalities must pass an offsite levy bylaw by stating the purpose and calculation method. Offsite levies may only be charged once, must be in proportion to the benefit to the new development, and must be used for the intended purpose. The calculation of levies Engagement requirements and reporting elements are defined in legislation and the offsite levy regulation. So the next slide. Development permit is the process by which municipalities approve specific developments. This helps to ensure development applications are consistent with statutory plans and enhances the rights of the applicant and surrounding property owners. So there's more about development on the next slide. So this might look familiar to you. In your land use bylaw, you'll have a district. So you'll have items shown under permitted and discretionary uses. In this particular case, permitted uses allow for a dwelling or home occupation, so a minor business. And on the right side, discretionary uses, which is a bed and breakfast or home occupation major. In addition, there's additional regulations for development in this district. So we have development standards. In this case, it allows for a maximum of 2 dwelling units. And then we also talk about the setbacks. So minimum setback and then the front and backyard setback. So your land use bylaw will have additional information, I'm sure. So I've left it as a question because it depends on what your land use bylaw says. The bylaw should address variance by the development authority. And the appeal board may address variances on the lot that exceeds the development authority's authority. So you may want to keep thinking about, in case your land use bylaw is missing it, you may want to think about what other issues can be regulated for a development. Perhaps the height of the building, minimum number of parking stalls, etc. So that may be something you may want to consider when reading, or if you're choosing to rewrite your bylaw at any time. Next slide. So this is the development process. When a development permit is received, you have 20 days to deem whether that permit is complete. So as long as there is no outstanding information, you may deem that to be complete, and then you have 40 days to make a decision. So within those 40 days, you have that time to determine the application review. It's reviewed against the statutory plans and the land use bylaw. Also within the 40 days, you need to make a decision. And you may include conditions. You must state the reasons for the refusal. And if it's deemed refused, if no decision is made within 40 days. Within that time, after the 40 days, it may be appealed. And you have 21 days to file that appeal. So you have 21 days to appeal any decision, and any affected party can appeal. Unlike subdivision, the adjacent landowner for a development permit process can appeal, but there are limits under subdivision. So it's a little bit different. So you may want to review those sections in case you have any questions about that. So next slide. So basically, I previously had talked about non-statutory plans. So this provides for an additional layer of planning. So this is totally unique to all municipalities, and it may depend on how your municipal planning documents work with each other. So this is not the perfect explanation of what statutory plans are, the variety of them, as you write your plans and how they work together with other documents. But in generality, you probably will have something in regards to road standards and approach installation standards, design guidelines and construction standards, something on resource extraction, perhaps on your offsite levy bylaw and so on. And I add this in because under section 618, Actually, I need to double check that part. 638, there's a requirement that you must publish all plans if you plan to use them in making planning decisions. So that was a new thing that was added to the MGA back in 2020, that if it isn't published, you can't apply that decision, apply those policies as part of your decision-making process. So you may want to review your documents just in case. So we'll move on to the next slide. To other planning-related items. So in terms of working with others, we also have two notable things: ICFs and JUPAs. For ICFs, or intermunicipal collaboration frameworks, the purpose of this part is to provide for intermunicipal collaboration frameworks among two or more municipalities. A, to provide for the integrated and strategic planning, delivery, and funding of municipal services. B, to steward scarce resources efficiently in providing local services. And C, to ensure municipalities contribute funding to services that benefit their residents. For JUPAs, or joint use planning agreements, a school board is operating within the municipal boundaries of a municipality must enter into agreement under the section with the school board. And I should have said not must, but most likely. An agreement under the section must contain provisions to establish a process for discussing matters relating to the planning, development, and use of school sites on MRSR and MSR in the municipality. Transfers under section 672 or 673 of MRSR or MSR in the municipality, the disposal of school sites, the servicing of school sites on municipal reserves, school reserves, and MSR in the municipality, and the use of school facilities, municipal facilities, and playing fields on MRSR and MSR in the municipality, including matters relating to the maintenance of the facilities and fields and the payment of fees and other liabilities associated with them. Next slide. So, Government of Alberta involvement. So back in 1995, under the MGA, when it was significantly rewritten back in the day, land use planning was delegated to municipalities. So as a result, we don't really play much of an interest other than legislation at this point. So we create the MGA, and so that's how we basically delegated the responsibilities to municipalities. So in relationship to provincial law, if there's a conflict or inconsistency between a bylaw and this or another enactment, the bylaw is of no effect to the extent of the conflict or inconsistency. So keep in mind that we also do have other ministries involved in land use planning as well. And you may have dealt with them in the past. For example, a lot of municipalities are involved with Alberta transportation if it's impacted by an Alberta highway, if it is a resource like water or environment or something like that, then Alberta Environment and Protected Areas have legislation on those respective matters. So formally, for provincial interest, you may be familiar with the ALSA regional plans, the Alberta Land Stewardship Act regional plans, and provincial land use policies. So the provincial land use policies were created back in 1995 when there was a delegation to municipalities so that they were responsible for land use planning, municipal land use planning matters. But the PLUPs basically provide a reminder of the relationship between the provincial government and municipalities and how we work together. So there is a link, or I will be providing a link in regards to PLUPs if interested. In terms of the ALSA regional plans, there are currently 2 regional plans in place that were approved by Cabinet. First one was in regards to the Lower Athabasca Regional Plan and the South Saskatchewan Regional Plan. So, and in regards to the PLUPs, once there is a regional plan in place, the provincial land use plan use are extinguished under our Act, and PLUPs are refreshed and placed inside the regional plans. So it's under the community development section. And so you may want to review the legislation, the regional plans in regards to any changes. So, and as well, there are subdivision referrals under the MRSDR. So in terms of referrals to other government departments. As well, the LRPRT also gets subdivision appeals, as I previously had covered. And as well, there's other places that are affected by decisions that work hand in hand together, such as safety codes. And so there may be numerous other departments also affected. So the next slide. So I had mentioned before too that there were additional resources. So if you're interested in getting subdivision and development appeal board training because you're sitting as a board member or as a clerk, the link provided will provide a link to the LPRT who arranges that training internally. However, you can arrange for other providers to deliver that mandatory training if desired. So if you want to learn more about land use planning, there are courses through the Faculty of Extension through the University of Alberta, through the Applied Land Use Planning Certificate, and all these were quite valuable, and you may want to learn a little bit more. And as well, if interested too, the Alberta Development Officers Association, the ADOA, also provides a manual that if you're a member, you will get access to that manual, which will be very helpful, and access to a lot of other development officers that you can ask questions that may provide assistance to you as well. So, and then moving to the final slide, that brings us to the end of our presentation.